Can you hear us, Quello?
Can you hear us, Quello?
Good morning.
Yes, I hear you. Good morning. Good morning. Just waiting for the others to connect.
Right.
I see the three counsel, Mr. Quello, Mr. Pettingill, Mr. Lynch, Miss Greening, and Miss King-Dean.
And
You can or cannot see them?
I can see each of them.
And I can see Mr. Mahoney.
No, I can't.
And Mr. Mahoney, yes.
Is Dame Elizabeth on the call? I cannot see her.
Yes, you can. I'm here.
Oh, there you are. All right. So good morning to everyone. This is the Court of Appeals sitting in Bermuda for the extension of time applications for Quincy Brangman, Khyri Smith Williams, and LeVeck Roberts. This is calling Criminal Appeals number 4, 8, and 9 of 2020. Mr. Jerome Lynch, QC, and Mr. Mark Pettingill and Ms. Sarah Ann Tucker are representing Mr. Brangman and Mr. Smith Williams. Ms. Victoria Greening is representing Mr. Roberts. Mr. Mahoney and Ms. Karen King-Dean are in for the respondent. These proceedings are taken before my lords, Sir Morris Kay presiding, Mr. Justice of Appeal Jeffrey Bell, and Mrs. Justice of Appeal Dame Elizabeth Gloucester.
Thank you. Can we now see counsel? I can't yet. Oh, there we are. Well, good morning, everybody. We've managed to do quite a lot of reading that you've supplied us with over the last few days, and things have started to clarify. The first issue in the case, as we, I think, made clear the other day, is whether any particular applicant can mount the numbers hurdle. Because if, in fact, there were only 3 or fewer standbys, it's difficult to see that he was prejudiced. Now, it seems to us that, having looked at everything and what's been said about it, Roberts and Smith Williams get over the numbers threshold. If Mr. Mahoney wants to take issue with that, he of course can in a few moments, but that seems to be our provisional view. Brangman is more difficult in that on the face of it, it looks as though there were 3 pure standbys, and there were then some other challenges which, in the language used, become a little bit obscure. So I think maybe the best thing to do is, I don't think we need to hear Mr. Lynch, Mr. Pettingill. Sorry, we don't need to hear counsel on behalf of Smith, Williams, and Roberts at this stage on the numbers point. But we do need to hear Mr. Mahoney in relation to those 2 applicants if he's disagreeing with what we're saying. So perhaps we can hear from Mr. Mahoney on the numbers issue in relation to Roberts and Smith Williams.
Good morning, my lords.
Good morning.
In respect of Roberts, I must first indicate that our schedule needed a bit tweaking, and I apologize for that. I just noticed it when I look back over the schedule, because when one look at the transcript for Roberts, starting at page 49, One will notice that at that stage, all the standbys were actually recalled,
Right.
and the court went through all of the standbys. So the first
Sorry, what do you mean the court went through all of the standbys?
Yes.
At this point, the standbys have been stood by. That pool being exhausted, the judge then has the obligation to go through them and see if any can properly constitute challenges for cause.
That is so, sir.
Yes.
And of the, so from page 49 onwards, you will notice that from standby number 1 up to 33 were all recalled. And of those, 28 were excused for cause. And 38, 2 were the initial standby by the Crown, reestablished cause for 2. We were not successful with.
Mr. Mahoney, can I stop you? And I don't know whether you feel it's best done by your schedule, which helpfully does give the page number and the line, but I don't get to that high number that you seem to have got to.
I'm sorry, sir. This schedule, what we did is, the error on the schedule is the standby numbers went up to 42. There were not 42 standbys. There were 33 standbys.
Right.
And when you look at transcript at page 49 of the transcript, you will notice that the standbys are started to be recalled. And the judge would indicate the standbys by their number, the order in which they were stood down. So the first standby recall was Joseph Dawson.
Yes.
And that's at line 7.
And going through to the top of the next page, the judge stood him down.
Yes, because I think some work commitment with fishing or something like that.
He was the fisherman.
Then the next one at page 50, line 3 was Sharon Gardner. And we were successful in challenging her for cause.
Well,
that's page 50, line 3. Continue over to page 51, line 21.
Right.
The next one, number 3, was Trevor Smith. Page 51, line 22 to page 52, line 13, who was grieving the sudden death of his brother.
And he was stood down by the judge.
Yes, sir. Then Darrell Wayne Scott, number 4. Mr. Attridge agreed to that person being excused. I think he was Mr. Attridge's client or something like that, I think. Can't recall exactly why. But that's page 54 over to page 57, line 8.
Sorry, which juror are we dealing with at this point?
Darrell Wayne Scott.
Wayne Scott Darrell, you've got it in your, yes?
Yes. Then we have Michael Wellman, number 5 at page 57, line 20.
But just going back to Darrell, the reference you've got in your schedule is page 14, lines 13 to 25, but I suspect that there's a further reference.
Yes, sir. That's why I indicated that on reviewing the schedule. This
right. Just give me the proper reference.
Okay. So he first appeared at page 14 when he stood down, but he was recalled at page 54, line 2.
Yes. And Mr. Attridge says he should be excused.
Yes, my lord.
Yeah.
Then the next person was Michael Wellman, page 57, line 20. To page 58, line 17.
Where the judge says stand down.
Yes, yes, sir. That person knew one of the defendant's family well and also had a civil matter with one of the defense attorney.
Right.
Then number 6 was Felicia Mahon, page 58,
Yep.
line 21 to page 60, line 5. She was a school principal and she said she was familiar with one of the accused.
Right, but the judge said stand down.
Yes, sir. Excused. She was excused. Well, she was excused, but he used the phrase stand down.
Yes. He said at line 5, I think cause is established.
Yes, my lord. Then next was Carolita Durham,
Yes.
who at page 60, line 6 to 14, knew one of the victims, that was Haile Outerbridge and his family. She was excused.
Line 19, the judge says she could stand down.
Yes, sir. Number 8 was Leanne Simons, page 60, line 15 to 19. Who was a friend of the deceased Haile and a co-worker. And we all agree that Ms. Simon should be excused.
Well, the judge says it, so that's what counts.
Yes, my lord. The number 9 was Sanchez Wilson. Cause was not established, and she was empaneled. That's at page 60, line 20 to page 63, line 19.
Right.
Then page 64, I think then the co-defendant, Christopher Deere, challenged juror number 62. And after that, we had Winifred Dial. Page 66, line 19 to page 67, line 7. She sent a note to the court, which was shared with all counsel. And we all agreed that she should be excused.
Well, and the judge ordered it at
Yes, my lord.
67, line 7. I mean, I think we need to bear in mind, Mr. Mahoney, that strictly you can have standby and challenge for cause. And it's the judge who rules on challenge for cause, and he appears to have done so in this case on the basis that all counsel agree.
Yes, my lord. The next one was Keith Jensen, page 67, line 8. And we came back to him at page 89, line 1.
Sorry, not 89?
Sorry, I think my number there may have been in error. It started at page 67, line 8.
Yes.
I think it's up to page 68, line 1. He had a traveling commitment on the 4th.
Yeah, he wanted to go see his new grandson.
Yes, my lord.
And the judge agreed to that.
Yes, my lord.
68, line 17.
The next one was Dwayne Crockwell, page 69,
Yep.
line 1 to 22. And we all agree that he was to be excused based on his new job.
And the judge so ordered.
Yes, sir. Yes, sir. Doris Williams, page 69, line 23 to page 71, line 23. And we also came back to her at page 89, line 7 to page 91, line 25.
Sorry, page again?
Okay, she first featured in recall at page 69, line 23, page 71, line 23.
She was effectively stood by at that point rather than challenged for cause.
Yes, 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 sir. But we came back to her at page 89.
Right.
Line 7 to page 91, line 25.
So the judge rejected any challenge for cause.
Yes, sir. Yes.
So said she was called.
Yes, sir. Then Gavin Kennedy, page 72, line 2. He had an indication that he was excused by the Chief Justice.
Sorry, what was his name, Mr. Mahoney?
Gavin Kennedy.
Kennedy, thank you.
Top of page 72.
Yes, sir. At line 2.
Is that you speaking there, saying, so I guess cause is established there, or is that the judge?
At what line are you referring to, sir?
Line 2 of page 72.
I think that's the judge, sir.
It should be.
It should be, because he then went on to say P15. He was the one calling out the standby numbers.
Yes. And he carries on talking about Linda Graves.
That is so, sir. And Linda Graves, page 72, line 3 to page 73, line 12 was stood down for the time being.
Let's use the proper language. She was told to stand by for the time being.
Yes, sir. Then the next one was number 16, Sandra Simons. Page 73, lines 13 to 15. Knows one defendant, so agree that one is out. So she was excused. Then Claire Mello, number 17. That's page 17, line 16 to 24. Goodbye for the time being. Next was number 18, Troy Baisden.
Sorry, Mr. Mahoney, I had someone walk into the court where I'm sitting.
I'm sorry, sir.
Where is the...
Claire Mello was number 17.
I was going on to the Belco employee.
Yes.
Mr. Baisden.
So Mr. Baisden was number 18.
And the judge said, I don't hear any cause established.
Yes, so he was empaneled. I think he wanted to be excused because of work.
Yeah.
None of us acted on that. Then Mr. Deere, the other co-defendant, challenged one of the jurors, Teresa Andrade, at page 74, line 19 to page 75, line 1. And then we continued to Corinne DeMello, page 75, line 2 to 6. She was excused.
Yep.
For medical reasons. Then number 20 was Leonard.
Just interrupting you for a moment, Mr. Mahoney. I mean, as we go through these, one of the difficulties one's got, if I look at your schedule of jurors challenged, and we just look at that last one, Corinne DeMello, you've simply got traveling end of month to hospital. You don't have any reference to the fact that the judge has said that cause is established and that she should be stood down.
That's why, sir, I apologize, because I should indicate on Sunday we're doing a rush job to meet the deadline.
Yes, the deadline was tight. But what I'm...
My apologies, sir.
What I'm wondering is how we get to go through all of these standbys to determine whether anybody in that list or how many of the people who were originally stood by either have their challenges for cause heard and allowed or challenges for cause heard and disallowed.
The total, sir?
Sorry?
I did a summary. The total excused were 28.
So where is the summary?
In my submissions, in my addendum submission.
Right.
3 were empaneled.
Right. Yep, got it. Thank you.
And so I undertake to redo the schedule, but it is there in the transcript. The evidence is there as to who were challenged. Everybody was actually recalled. And the reasons were provided there. So I don't know if His Lordship want me to proceed down to the end. We're almost there.
I think it would help me at some stage if you went through Miss Greening's list, just concentrating on the ones she's highlighted in yellow.
Oh, very.
I think I can cross-refer from some of the things you've said. That she says that all her yellow jurors were stood by the Crown in some form or other.
Well, I could do that quickly, sir. But I would just want to make an observation. One should recall that there were 2 defendants in this case. So the numbers identified have to be split between the 2. And even on Miss Greening's schedule, if you split 2 under the new legislation for premeditated murder, we have up to 5 challenges, not 3. So when one look at her schedule, you count 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I'm going to go through all of those, 11, 12, 13. I'm going to go through all of those. The first one was...
Just before you do, you say
yes,
it was a trial of 2 defendants, which I understand.
Yes, sir.
Does that
And
mean you're contending that in effect you had 10 challenges, peremptory challenges?
Well, under the new legislation, we would have.
We should be talking about the
Come back.
legislation. We should be talking about the legislation that was operative at the time, shouldn't we?
Yes.
Yes. So I'll come back to that. So I'm just trying to deal with the.
Yeah.
As part
Well,
of
I just need to know what you're saying. Are you saying that you had 3 challenges per defendant, so 6 rather than 3?
No, my lord. Under the new legislation, it is 5 per defendant because of the nature of the offense.
Was that in force at the time of this trial?
No, sir. What was at the time?
Why are we talking about it?
Excuse me, sir?
Why are we talking about legislation which wasn't operative at the time of this trial?
Well, because that's part of the submissions that I think Ms. Greening has made. But can we defer the legislation discussion until later, sir?
Yes,
But I think to answer my Lord Justice of Appeal Kay's question, if you go down the list submitted by Ms. Greening showing the standbys by the Crown highlighted in yellow, virtually all of those as we go down, Dawson, Gardner, Smith, and so on, were subsequently challenged for cause, and in the vast majority of cases, that was allowed. So that Dawson, if we cross-reference with your list, Dawson was excused by the judge.
Yes, sir.
Gardner was excused by the judge.
Yes, sir.
Trevor Smith was excused by the judge, and
Yes.
so on.
And
So,
Wellman as well.
yeah, so I think that answers my Lord Justice Kay's question.
yeah.
Yes, my lord. Sanchez Wilson was empaneled.
Yes.
Lakelia Richardson. Trying to see where her name is on the recall list. I don't see her name on the recall list. Gina Dean was empaneled. If you go to page 76, line 17, she was eventually empaneled. And I should indicate, sir, that she had actually sent a note to the judge, which was shared with counsel. And on that basis, she was stood down.
Well, the judge said stand by to start with, and then he stood her down.
Yes, sir. But eventually we came back to her at the end of the recall process.
Dean, when the judge asked any concerns, there were none. So presumably she was impaneled, was she?
Yes, sir.
So that's line 76. Sorry, page 76.
And I continued over to page 77.
Yes.
Line 17. Geraldine Roberts is the next one on Ms. Greening's list. That's page 77, line 18 to page 78, line 12. Cause was established.
Yes. And the judge says stand down.
Yes, sir. Sylvia Bento, page 78, line 13 to page 80, line 2. Cause was established.
Yes.
Here, Jaquito Rawlins.
She's on page 80, line 22 onwards.
Yes, sir. Cause was established as well. Thanks. A note was actually sent to the judge, which was shared with counsel. Cynthia Basamasi.
Where do we see what the judge did with Rawlins?
Rawlins is at page 80, line 21 to page 84, line 6.
So the judge says he's ruled, stand down.
Yes, sir.
Yep.
I don't see Miss Basamasi. In fact, I don't see that name at all here. Or if I'll just proceed to the next one. Tika Hassel, page 84, line 8 to 14.
Cause established.
Yes, sir. Lucinda Laws, page 84, line 15 to 18. Cause was also established.
And that, I think, is the end of the ones highlighted by Miss Greening in yellow.
Yes, sir.
So is this your way of putting it, that you may have used your power to stand by in relation to some or all of these people initially, but having been stood by, they were then reconsidered, at which stage they were stood down for cause?
Excuse for cause, sir.
Yes.
That's
So,
Or in the case of a very few impaneled.
yes, sir. Some were in panel, 3 were in panel,
And the balance was,
the rest were excused for cause.
yes. And, right.
if they hadn't been reached in round 2, they would simply have been stood by you, and nobody would ever have known why.
Not necessarily, sir, because when one goes through the transcript, the vast majority of the jurors had given some indication of concerns or difficulty, and on that basis, they were stood by.
So in those cases, are you saying that they'd indicated some difficulty via the prosecution, and on the basis of information in your possession, you stood them by?
In the vast majority of the cases, yes, sir. In respect of Roberts, where the empanelment started at page 12, as the jurors were called, you will see where, for the vast majority, they gave some indication of difficulty, either travel plans or what have you. Hence, when we came to the recall, you will observe that in the transcript, there was not much dialogue there. The judge would say, cause is established, this person is traveling, or know the defendant, or know the deceased. And that's because that was already indicated at the start of the process.
So going to page 12, Mr. Mahoney, when you stand down Mr. Dawson right away, you stood by Sharon Gardner right away, over the page, stood by Mr. Smith right away. That was on the basis of information that you already had?
I can't recall, sir. Maybe 1 or 2, but I can't recall for all of them, sir.
Right.
So if you go to page 14, you will see where Mr. Darrell made an indication that he knew both the deceased families.
Yes, and you already recognized at that point that the exercise was going to have, you were going to have to go through the exercise again because of the number of standbys.
That is so, sir.
Yeah.
It's actually the practice of the court where we try to see if we could empanel the jury as much as possible without having too much interruption. So if our juror indicates an issue and the judge is not minded to excuse immediately, or we wish to explore that, instead of taking the time to do it then, we go through the standby and revisit the issues at the end of the exhausting the list, so that it's possible we could get a panel without having to go through all of the standby. If not, we did what was done in the LeVeck Roberts case.
Just looking at the notes I've been making while you've been speaking, Richardson, number 44, was stood by you and was never empaneled or stood down by the judge. Is that right?
Is that Lakia Richardson?
Yes.
It would appear so, sir. I don't see her name appearing again, sir.
Yes.
Not in your schedule.
No, sir. I would have to check my notes. What may have perhaps occurred sorry. Lakia Richardson is supposed to have been standby number 23. If you look at page 76, line 1 to 16.
Oh, she's called Richards there.
Yes, sir, but that's number 23, and
Yes.
it was Nakia Richards by the judge.
So he says in terms, and line 16, causes established, stand down.
Yes, sir. So I believe it's the one and the same person. If one look at the standby number.
Yes.
I could go to the Khyri Smith-Williams matter if there is no further assistance I can give to the court.
And when you were standing them by first time round, you say you were doing this on the basis of information you had. At that time, that information in many cases hadn't been shared with the defense, had it?
I'm not sure, sir, because there are times when, like, for instance, Wellman, I am aware that Wellman may have been related to a Wellman who was a member of the MOB gang. All the three defendants in this matter are alleged to be MOB members. So the name Wellman, when I heard the name Wellman, I stood by out of abundance of caution, because it's possible that he is related to the Wellman who is a member of the gang. As it turned out, when his name was recalled, he indicated that he knew the family of one of the defendants.
Yeah.
So my hunch was correct. There are also times when we say standby. The defense attorney may send a note to us or whisper something to us, and on that basis, we say standby. So the fact that we say standby doesn't necessarily mean it was information uniquely in our possession. It could also have come from the defense attorneys as well. So going back to Ms. Greening's schedule, if one was to take out the persons who were excused for cause in which cause were established, and include also those in which cause was not established and they sat on the panel, the numbers are pretty much within the range.
Well, that's a vague expression.
Yeah. What was the number, Mr. Mahoney, of jurors who were stood by but not either impaneled or, I'll use the phrase stand down, which is the phrase the judge used, which I take to equate to a challenge for cause having been established. So were there any who stood by who did not then fall within either of those two categories, impaneled or effective challenge for cause?
Well, 3 were impaneled, or we couldn't establish cause. 28 were excused for cause, leaving 2 that were stood by and we didn't reach back to.
Right.
Because in total, there were 33 challenges. 33 standbys, sorry.
Right.
Yes, sir.
So it comes 3, 28, and 2.
Yes, sir. And again, I repeat that one also have to remember that the Roberts case, there were 2 defendants.
But what difference does that make?
It makes a difference, sir, because whatever number is there has to be split between the 2. It can't be that he's complaining that there's not the fact that he was the only defendant. There were 2 defendants.
And so they have a total of 6 challenges for peremptory challenges between the 2 of them.
Yeah.
That is so, sir. So when one do the math of the 28 that were excused for cause, the 3 were impaneled and those that were remaining, one have to also bear in mind that this was a case which involved 2 defendants. Yep. Unlike the other 2 cases where there were individual defendants only.
Yeah.
Can I go to Khyri Smith-Williams? No, sir?
No, I think we'd like to sort out the numbers as far as Roberts is concerned first.
Oh,
so
sorry, sir.
We'll hear Ms. Greening on numbers in Roberts' case.
Very well.
Yes, Ms. Greening.
She needs to unmute herself.
Can you hear me?
You're muted.
We can. Yes.
I apologize. It's not so much the numbers that I quibble with when it comes to Mr. Mahoney's analysis of the jury transcript, the transcript in relation to the jury selection process. I also put together a table and went through the transcript carefully myself, and I'm in agreement with the 14 highlighted in yellow standbys that I say the Crown exercised unilaterally at the start, as he was entitled to do so at the time, and that a number of them, well, all of them came back latterly. And my position is that does not matter. It's and I, with the greatest of respect to Mr. Mahoney, I do not and cannot accept that his position is that he was acting out of convenience because of some information he had about travel leave, medical leave.
Well, Ms. Greening, just to interrupt you, I think the first question is whether you agree with Mr. Mahoney's figures, which were that 3 were impaneled,
Yes.
28 were excused for cause, and in two cases, the standby held. Do you agree with that?
I do agree with it. The only one that I have got a big circle around is Cynthia Batamasi. I can't see what happened with her.
Neither could Mr. Mahoney, and I think she is probably one of the 2.
Yes, okay. Well, in that case, I don't have any quibble with his numbers, no, my lord.
Right.
But your point is that you're still prejudiced by the procedure, is it?
Absolutely, yes. I mean, it's a game of probability and statistics that and strategy that is afforded to the Crown and not to the defence and whether or not all of those standards come back or not.
And that goes back to the point my Lord Justice Kay made earlier, which is that if the standby had been maintained
Sorry, my lord, I've lost you.
Yes, I've lost you as well.
You're frozen, Jeff.
Yeah, he's frozen.
You're
Now you're
muted now. We should be able to hear you now.
I can't even.
Justice Bell, can you say something to us?
yes, indeed, I can hear and I'm unmuted.
We can hear you. You were saying?
Sorry, I have a note. It goes back to the president's point that if the standbys had been maintained, and then I lost you.
If the standbys had been maintained, that would be one position, but where the standbys, where it is established that they were either empaneled or excused for cause, as was the case with 31 of the 33 potential jurors, that's a rather different scenario, is it not?
In my submission, no, it's not a different scenario when it comes to the test that needs to be applied, my lord.
Ms. Greening, could I ask this point, please? Is your argument that this is all a tactical process, and if there is this superior ability in the Crown, it can game the system of standing by jurors more effectively, even if they are subsequently empaneled, or even if, because, for example, it could be said that it gives a juror an opportunity to appreciate that if he or she puts up a good reason, he or she might be excused on grounds, stood down on grounds in any event.
Yes, my lady, that is precisely my point. And that's why I had thought it would be useful to hear from the Crown on precisely why they stand by why they are standing by, because it's my position unequivocally that the Crown, and it's no criticism of the respondent in this case, because it was the way the standard practice was, but it was abused and manipulated in order to formulate a jury that was going to maximize their chances of securing a conviction. And that is just simply unfair, grossly unfair. It's a tactical game of probability to maximize those chances to the detriment of the accused, both of the accused. And that's why that's why earlier I had said I do not and cannot accept the Crown's position that they are acting out of convenience because they somehow know or have a hunch, to use the respondent's, my learned friend's term, that they will come along later on and exercise their, or provide an excuse to try and get out of being a juror. Having been a prosecutor and a defense lawyer myself, we are never afforded the letters and excuses and information prior to a jury being impaneled, to the extent that I think my learned friend is trying to suggest at this hearing. I think he's starting to reveal a bit more of what the prosecution's tactics were when he said that he recognized the name Wellman. He thought that he might be a member of MOB. His hunch was correct. That's the kind of tactical approach that the prosecution were using and abusing for their gain. And it's grossly unfair. And so it matters not in my submission that 28 of the ballot were excused for cause latterly.
But if Mr. Mahoney, for instance, with the case of Wellman, had chosen to challenge for cause instead of standing by, arguably the whole process of jury selection might have taken a great deal longer. And what the Crown was in the habit of doing was not doing a full challenge for cause, but doing a standby while they determined whether it was possible to impanel the requisite number of jurors without going into the challenges for cause.
Well, that was his response. That was a responsibility that he took to stand them by rather than challenge for cause. That was a tactical move in my submission on the prosecution's part to exercise his unilateral and unlimited standby, as opposed to at that early stage. And I cannot accept again that it's for any sake of convenience to shorten the length of the jury selection process.
So you're saying that he should have challenged for cause on those occasions when he stood by?
Yes. If there, yeah, absolutely. And I also cannot accept that, and do not accept the position that notes are getting passed back and forth in silence between the prosecution and defense. We have three very outspoken defense lawyers in this case, Mr. Attridge, Mr. Richardson, and Mr. Mussenden, and I note that none of them uttered a word until page 42.
But that's understandable, isn't it? When the system was operating in those days on the basis that the standby was the Crown's right.
Absolutely, my lord, but that's just in reply to Mr. Mahoney's suggestion that there were discussions between Crown and defense that we cannot hear that led to him standing up and exercising his standby, his right to stand by.
I thought that most of the notes actually came from jurors who preferred to put their reasons for not wishing to serve on the jury in writing rather than having them spoken out loud.
Yes, latterly, and those letters and notes are produced and handed down to the lawyers to read after the Crown has stood by the first round, as it were.
Right.
I also do not accept the position that the Crown takes about two defendants. I find it preposterous to suggest that because my client was standing next to someone of whom he had no influence over whatsoever, that his three standbys should be included in each other's, if you know what I mean. Sorry. I cannot accept the position that because there were two defendants in this case, and each of those defendants had three standbys, could exercise
challenges.
up to three challenges, that therefore the number that we should be, the threshold we should be looking at in co-defendant, in multi-defendant cases should be in multiples of three, depending on how many defendants there are. When
an academic point in this case, isn't it? Because according to Mr. Mahoney, there were only two standbys.
Yes.
At the end of the day.
Yeah.
Now, is this your point, that as it played out, there were a large number of standbys, but a considerable number of them were later stood down for cause or empaneled? But that was as it played out. It could have happened that by the Crown's large number of standbys, you would have reached a full jury without coming back to some of those for cause challenges. And you would never have known what the cause was or why those people had been challenged.
President, that absolutely is my position, and I go into it in my submissions as well. I think it would be very helpful to look at all of this in the particular context of Bermuda as being unique in its makeup, and particularly racially so. And this fact coupled with the very powerful divergent feelings that are stirred up, particularly by gang violence. We have to look at the particular facts and circumstances of each case, and how a jury selection process through against that backdrop amounts to such gross substantial injustice and gross unfairness. It makes it all the more important in my submission for a defendant to be afforded the opportunity to have a fair cross-section of jurors from the start, from the beginning of their trial.
Is that all you want to say about numbers?
That's all I have to say about numbers, my lord, at this stage, yes, but I reserve my right if anything comes up.
Right. Well, maybe we'd better hear Mr. Mahoney on numbers in the case of Smith-Williams.
My lord, in respect of Smith-Williams, I just want to point out to the court that when one listens to the actual recording, it does not necessarily accord with the actual transcript. In the Smith-Williams case, some of the prospective jurors actually passed up notes and letters to the court, which was shared with counsel, and it is not reflected in certain areas of the transcript. I just want to give you an example of that. For example, at vendor trot.
Sorry, give us page number.
Vendor game, sorry. vendor trot is page 13,
Yes.
line 20.
Is this, Mr. Mahoney, is this before the witness list has been read out?
Current on it, sir. Yes, sir.
All right. But we've got, I mean, this is a good example of frankly, the use of incorrect terminology, because the prospective juror produces a note from her doctor and describes her medical condition. She's in constant pain. And you say, "Stand down, sir."
Yes, sir.
Right. With respect, it's not up to you to say stand down, is it? That's unless by that you mean stand by. But the court says, after you've said stand down a second time, the court says stand down, sir. So did that represent a challenge for cause, or was it just misuse of the words that appear in the section, which are stand by?
Well, sir, I would have to agree with Mr. Pettingill in his submissions, because the practice is the words stand by, stand down tend to be used interchangeably.
Well, that's regrettable, because the word stand down doesn't appear in the section which refers only to stand by or challenge for cause.
That is so, sir. But likewise in the Jury Act, there is nothing there that indicates stand down. It indicates that the judge may excuse. Yet,
yes,
invariably, the judge seems to use the term stand down instead of excuse.
Excusing, but here, I mean, certainly the section says that it's the judge who should rule on the challenge for cause. So it shouldn't be you saying stand down, sir, unless you mean stand by.
That's what is meant, sir.
Right.
Whenever I say stand by or stand down, it's meant stand by, not stand down for challenge or cause.
But in the examples we looked at in the Roberts case, where the judge reached the conclusion that the particular juror should be excused on the basis that challenge for cause had been established, he actually used the word stand down.
Yes, sir, but I humbly submit it's not a term of art, because other judges don't use the phrase stand down. They would say excuse for cause.
Right. So when, in relation to the transcript not being correct, what do you say is incorrect about it?
Well, for instance, witness Trot, a note was actually passed up to the court, but it is not reflected in the transcript. But if one listens to the actual recording, you will hear the rustling of paper.
Right. But she's got a note from her doctor which she produced.
Yes, sir. As I indicated, sir, not everything that happens in court are necessarily captured by the recording system.
Well, I listened to the recording and I agree with you.
A juror may just, the name is called, she approached and she hand up a document. It goes up to the judge forwards it to counsel, we send it back, and next voice you hear is the judge.
Yes.
So just to indicate, sir, that in respect of, and there's one other person I wish to draw your attention to, Mr. Hurdle.
Sorry.
It was Dorian Hurdle. Page 3 of my schedule.
So page 28, 29 of the transcript.
Yes, sir. The transcript does not capture the conversation that was occurring at that time. And if you listen to the actual recording, you will hear when I mention that she works in the AG's chambers. And the recording that is captured at 54:14 of the recording.
54:14 being minutes and seconds.
Yes, sir. So in relation to Mr. Lynch's schedule, I noticed that he also included in his schedule an indication as if it was just the judge and the Crown that were involved in this process, but that is not necessarily accurate. The practice is once a prospective juror raises a concern, the judge usually looks to counsel, especially if a notice passed, the note is shared with counsel, and then all reactions are solicited from the court. Sometimes counsel will look at each other and counsel may give up his body language would suggest that they don't have a problem, and then I would say stand by. Of course, there are times when, as in some of the transcript, you will notice that I would not budge until the judge actually persuade me to say stand by. But in respect of Mr. Smith-Williams' matter, what should indicate of importance as well is notwithstanding the standbys, Mr. Smith-Williams had no problem with the actual jurors who tried him. The only person who he took off was a David Cashin, who was an alternate juror.
Well, can we just go to
Yes.
Mr. Lynch's list, where, and I'm looking at the typed version, there were 2, 4, 6, there were 9 potential jurors who were stood by and no reason was given. I'm just reading from Mr. Lynch's list. Now, were any of those standbys subsequently recalled and questioned as to challenge for cause?
No, sir, we didn't get back to them. We were able to empanel a jury before.
That's the point, I think, Mr. Mahoney. Whereas in the case of Roberts, you've done a job going through each and every one of them and
Yes, sir.
followed through what the consequences of the standby were. You don't do that in the case of Smith-Williams. You do in the case of 2 jurors who you tell us about subsequent events and notes passed up and cause matters, but that still leaves about 7 who were stood by and then never reached.
Because, sir, for example, Ms. Linda Simons, I wish to correct that. We came back to her and I think she indicated that she was legal aid. She was the office manager at the legal aid clinic, I believe.
Sorry, which one was that?
This is Linda Simons. She was stand down number 12.
Right, number 12, where Mr. Lynch has just a question mark for her name, but you've probably been able to identify where it was said.
Speaking for myself, I'm concerned with appearances in this case. And the appearance in Smith-Williams' case is that you stood by about 9, maybe 3 of whom were subsequently excused for cause, that the other 6 just disappeared from the panel because they were never reached the second time round. Is that an accurate description of the arithmetic?
Khyri indulgence, sir. One.
From a defendant's point of view, he would have seen 9 people stood down, 6 of whom he never discovered why they may have been stood down, because they were never reached in the second round.
Stood by. Sorry, sir.
Stood by.
I would say 5, sir.
5. Okay, 5. Yes, because of the ones you mentioned.
Yes, sir. 5, Tony Lee Curtis was 1. Geraldine Simons, Crystal Simmons, and Shanae Headlam Lathan.
Yes.
I think, well, if we need to do the exercise, we should look at the transcript. I think my Lord Justice Kay's point is we don't need to do the exercise.
Well, we don't need to do the exercise if it's agreed that there were 5 who were stood by and not reached the second time round.
That is so, sir. And that was because we were able to empanel a jury.
Yes.
Before then.
Yeah. Okay. Is that all you want to say about Smith-Williams on numbers?
Yes, sir.
Right. Mr. Lynch, or Mr. Pettinger, whichever of you is in charge.
I'm certainly going to deal with
numbers. Smith-Williams on numbers alone at the moment.
Yes.
Mr. Lynch.
Can I take the shortcut that's been suggested to this extent? You'll have seen from my schedule, and indeed the note that I had, that it was made contemporaneously with the jury being sworn, that I provided to the court. Both of those documents, in our respectful submission, accurately reflect the position, save perhaps 1 or 2 observations that have been made by my learned friend and indeed one of your number, that listening to the transcript rather than looking at the transcript, listening to the recording, forgive me, rather than looking at the transcript, might indicate that there was some sotto voce reference one way or the other. Either way, as a bare minimum, 5 were challenged without any cause given at all. We would submit that the number is larger than that, but it perhaps for our purposes, we need not dwell on those unless it becomes important for some other reason. But certainly our submission, at least.
Mr. Lynch, a question on your list.
Yes.
Your handwritten contemporaneous list. Most of the time you say stand by, but sometimes you write stand down. Is stand down intended to be applicable in the case of a challenge for cause, or might it be a misnomer for stand by?
It might be a misnomer for stand by. I've tried to use the proper language where stand down should be caused by the judge and stand by by my learned friend. But it's entirely possible that in the heat of doing it, I may have written down one rather than the other when Mr. Mahoney used the expression, perhaps wrongly at the time. So I think put my hand on my heart and swear to it.
Yes, yeah. I think everybody's made that mistake, including the Chief Justice in the judgment in Jamaica Trout.
I think right at the very beginning, isn't it, in the first paragraph or so, yes.
Yeah.
Yes, I think that's all I would wish to say at the moment about the numbers. I know that Mr. Pettingill has separate submissions in respect of Mr. Brangman, and perhaps you'd like to hear from him.
Yes, now in the case of Mr. Brangman, our initial reading suggests that he couldn't get over 3. I know Mr. Pettingill's case is that there were more than 3, if you compute in a particular way. But perhaps we better hear from Mr. Pettingill first in the Brangman case, and then Mr. Mahoney.
Thank you, my lord. Thank you, my lord. Am I heard today? I apologize.
You are heard.
Thank you, my lord. My lord, I was able to get some of the information later. I apologize for not the computer glitch, but your lordships will have seen I've filed additional submissions in this regard. Could I preempt that? And having listened to the discussion this morning and seize upon Lord Justice President Kay's point, that the whole issue here, the overriding issue in my submission, and this was indeed the case in Trott, where we actually had affidavit evidence filed by a Mr. Stovall, who was an independent teacher. It's mentioned in the judgment in the courtroom with his students, and he filed an affidavit on what the appearance of what transpired was. And indeed, there were reasons given later on in a reply affidavit by the Crown as to a lot of what we've heard today. But the crux of it is, at the time of the selection, as it's transpiring, the defendant doesn't know that. And to Lord Justice Kay's point, it is about the appearance of justice that is occurring. And this is where the whole Porter McGill position on the appearance of bias, the reasonable observer, really comes into play in this criminal proceeding. And that is a thread throughout, if I may, all of these matters, and what we have heard today. And I would invite your lordships and my lady to consider that must be, in my respectful submission, I think, and all of counsel, that must be the paramount consideration. How does this look to the defendant who is on trial? And then, yes, we get into this whole mix of stand by, stood by, stand down. And then there is the issue of cause. And I've endeavored to make the submissions that I have, if your lordships and my lady have those, with regard to what happened in Brangman. And I certainly agree that Brangman appears to be, he is less than the others. And I seize upon what Lord Justice Kay said the other day, which I did actually catch at a later stage, about it matters not whether there's 25 or the number. It's once you go past that minimum of 3, that equality of arms issue must, on appearance, come into play. So, my lords and my lady, if I could just look at my submissions and try to be a bit more clear about what happened in Brangman. Yeah. And my very, very clear and specific reasons in my submission as to why there is evidently more than 3 challenges, if we use that as the umbrella term, by the Crown. And I've endeavored to properly, I think, weave in the law as it applies there. And also, most importantly, what his lordship's directions were to the jury with regard to any concerns, because those are extremely relevant. They're well set out and they happen in every case. And that is what I would submit is the law that needs to be applied. So, my lords, my lady, I say it at paragraph 1, it's submitted that in Brangman, there were actually a total of 7 jurors that were, in my view, standbys, stand downs, but were not challenged for cause. 3 of those are very obvious, and I'll deal with that. The others are not as obvious, but I would say they are critical.
Three of them, Mr. Pettingill, are clearly standbys with no reason being given. But yes, in the other 4, reasons were canvassed, whether or not they reached the level of challenge for cause.
Right, my lord. But my lord, coming to your point, I was obliged to hear it this morning. you made the point to my learned friend, Mr. Mahoney, that it's not up to the prosecution to stand by. And that's a problem, because that's what comes down to part of the real issue with regard to appearance. And if I can just go through this, I'll show where it transpires in the case of Brangman, that in fact what happens, to your lordship's point, is it's the prosecutor that does the standing by or the standing down. And the appearance of that, in my respectful view, is unacceptable. And it amounts to a standby, a challenge by the Crown. It's not as it should be, to your lordship's point.
You shouldn't be using standby and challenge interchangeably. They're clearly two different things under the Act.
I agree, my lord. Yeah, I'm sorry, and I don't mean to be, but I think that is that's where a lot of the confusion occurs, and perhaps forgive me if I do that in paragraph 2, because that's a very, very important point. And the difficulty that arises, as you'll have seen, is the use of the word stand down and not necessarily the word challenge or the issue of cause or those words ever being mentioned. So, my lord, I say at paragraph 2, there's no legal concept, I think your lordships have indicated this earlier, of stand down. And I submit this is a misnomer for standby, which is the correct term, which was being used in section 519(2) of the Criminal Code, applying the law at the time.
I don't think that's right, Mr. Pettingill, because stand down are the two words that the judge uses when he seems to have reached the conclusion that a challenge for cause has been made out.
Well, I'll come to that if I may, my lord, but he never uses the word stand by. He does on occasion, but it's also, to your point there, it is the word the judge uses, and perhaps he should use it. But I think to your earlier point, Justice Bell, it's not for the prosecutor to ever use it in those circumstances. It should be, as you pointed out, for the judge. And that's the problem.
It's not for the prosecutor to use the words stand down, but similarly, there's no reason for the judge to use the word stand by, because that's the right of the prosecutor under the Act as it was at the time.
Sorry, my lord, I think I missed that. I think you were saying it's not for the prosecutor to use the word stand down.
It's not for the prosecutor to use the word stand down when it's intended to mean that a challenge for cause has been made out. And it's not for the judge to use the word stand by, which is a statutory right given to the prosecutor.
Agree with that, my lord. Well, look, perhaps it would help, as I've tried to set it out, if I go through my submission and one by one, and I think that becomes clearer. And I think it's important, if I may invite your lordships and my lady, I say it at paragraph 3. I think the key to this on the appearance is that the learned judge at page 4 of the record, with regard to consideration the jury should give if their name is called, it submitted those directions relate to issues of cause. And that it's a very important direction. And his lordship gives it quite clearly and unequivocally, in my respectful view, as to what a juror should consider, what the test should be. And not only that, but how the test, if it arises, should be addressed by the court. That's the key and paramount consideration. So paragraph 4 is the learned judge directs a jury must evaluate a concern about their ability to deliberate on the case and whether or not they are capable of rendering a fair verdict. Pause, my lords. In other words, it's not enough, and it is Bermuda. And take Wellman as an example. That's a well-known name, if you will. And Darrell comes up here. That's a well-known name. As is Smith. It's Bermuda. It's often said everybody knows everybody. That is probably why it's more important than ever than in jury selection when it comes to cause, that there is some testing done by the court with regard to the level of the concern, and I come to this in a bit more detail, and to what extent a juror may know the individual. It is not, in my respectful submission, as the judge makes clear at page 4, to just say, I know the family of Mr. Smith.
But this is all to do with the challenge for cause exercise.
Yes.
In relation to standby, the Crown has the statutory right to ask that a juror stand by, and when the prosecutor does so, the court, quote, shall order the juror concerned to stand by. So yeah, we're talking two different things.
So it becomes effectively, well, quite exactly. It is two different things. And if you don't get to the different thing, what you're left with is a standby. Like that is my point. If you don't get to the second thing, which is the appropriate level of testing that the learned judge sets out at page 4, you don't get there. And so de facto, what you're left with is a standby, for which we've heard the misnomer time and time again, stand down. But if you never get to the testing stage of the two different things, then what you're left with, in my respectful submission, must be nothing less than just a standby. And if I may, I think I can go through that succinctly and try to make it as clear as possible in answering that question.
Well, I think it would be helpful if we actually went to the numbers and the exercise as it unfolded.
Yes, my lord. I think I come to that. I think quite quickly, because I take them one at a time in my submission, my lord, and address each one, and then I think I can make it clear as to why that's a standby in my respectful submission, as opposed to a stand down. Right. If I could, I'll take that process right now, my lord.
So, paragraph 9 of your submission.
Lord, I say at paragraph 6, the judge properly.
I thought it was paragraph 9 of your submissions, but. Don't.
Well, with all due respect, I get into. I get into the issue of a juror before that, because and it's an important exercise, if I may, because it sets out, to your lordship's point, the second test, if you will, and it does actually occur in that instance. And I think it's an important point to make, because it distinguishes where it happens and where it doesn't happen in this case. Right. Well, if I may, so at 6, they say the judge probably directs the jury at page 5, where he says, 1, do you know the accused person or any of the witnesses or relatives or associates, my emphasis, my lords, in such a manner or to such a degree that you may not honestly, that is without bias or favor to any side, deliberate in this matter on the basis of the law you shall hear and the evidence you shall hear in the trial only. That's the test, if you will, for cause. It's submitted the fact that a juror may know a person to some degree is not sufficient to compel a judge to stand a juror down for cause, and that any issue warrants a proper consideration. In any event, it certainly is not. And my Lord Justice Bell, this is your point. It is not for the prosecutor to stand down or stand by when an issue arises. It's something, in my respectful view, that must.
Why do you say stand by?
Sorry?
You said stand down and then stand by. Stand down for the judge, stand by for the prosecutor.
Yes, my lord, but that's a problem. That in this case, the prosecutor is the one that goes on in a number of instances I'll come to use the word stand down. That's entirely the problem. I agree. Right. So this is where the appearance of it, the issue is created that is disconcerting. So at paragraph 7, it's made clear in my submission at page 14 of the record when a potential juror, Mr. Cook, indicates that he went to school with one of the detectives, Don Da Silva. And my lordships and my lady, look at the dialogue and what I'll say is the assessment that properly takes place here. Not to a great degree, but the assessment. The prosecutor at paragraph 15 raised the question with the court. I don't know whether this is the juror thinks he cannot hear it properly. All the juror says is I went to school with Mr. Da Silva, as it happens in many of these cases. The court replies, very key, we are not going to go that deep. Went to school with the man. I think on a sensible reading, one's looking at that saying, well, that's not enough. So what? You went to school with him. What else? In accordance with the direction. The judge says, you look at it and see what role that you think Mr. Da Silva is playing in the trial. And if he has a significant role, then he steps down. We can always call him back. Well, my lord, that would then amount to a standby, of course, but that's what the learned judge says there, using the term stand down. But he is saying, look at the role he plays, look at the significance of the relationship. We can always call him back is reflected, in my view, as a standby as opposed to challenge. But there it gets mixed up.
It's not the prosecutor's standby, is it?
Not, my lord. That's the whole point here. It's not the prosecutor. That's why I raised this as an example. It's an important example. This is where it gets done right. And on the others, to amount to the totals, is where it does not get done right. That's why I'm making this point, which is to your lordship's point. It's the second, this is the other type of test, right? So this one I'm saying is not the there's no issue with regard to this one. This is where I say it's done right. So Mr. Richardson said his credibility would be an issue. So now you've got defense, the judge, the prosecutor, all saying, you know, there are issues here. Now, interesting enough, the new amendment, which I say foreshadows that, and it's quite a sensible, if I may, change of the law, says, well, if all three agree, that's not a challenge or a standby by anybody. That's a case where a juror who's drawn to serve, if all of them agree, it's considered an effective challenge because the three agree. Eminent sense. The most of paragraph 9, the following now is the list of the jurors that are stood by and stood down. So with regard to Mr. De Silva, to Justice Bell's point, we'd see that I would describe that as the secondary one of a challenge for cause and a stand down by the judge. At
but
9,
it looks like a provisional stand down, doesn't it? Because he says he can be brought back.
It does, but with respect, then it would be a standby, my lord. So it's I'm almost conceding, I could see where one could try and develop an argument. They're saying there was an examination of cause, and that there's the misnomer is used again with respect to the judge. Perhaps he gets it wrong by saying we could always call him back, because if he's making a finding, and I'll come to this, then he should be stood down on the basis of cause. But he doesn't call him back, and it would be another standby, in my respectful view, because of those words. So look at paragraph 9, page 7, paragraph 25, and I'm referring to the transcript now. Juror 26, Khalid Muhammad, is stood by. That's number 1. At page 8, paragraph 8, juror 38, Nolan Simmons, is stood by the Crown. That's number 2. At page 15, paragraph 11, juror number 4, Herbert Christen, is stood by the Crown. The 3 standbys proper, if you will, or without confusion, happen in a row. 1, 2, 3. My lords, at Roman paragraph 9.4 of mine, this is where I say that the issues start to arise. At page 16, paragraph 19, the potential juror has indicated she knows the defendant's father, auntie, and the defendant, to which the defense indicates they have no issues. So this becomes one, unlike the De Silva one, where they're not all agreeing. The court seems to consider this and indicates on queries at paragraph 17 the following: she does enough. That's enough. It's an important point that is the prosecutor at paragraph 19 that stands the juror down without further consideration by the court. Only a direction from the judge at paragraph 21. I'm not sure who he's talking to here, my lord. I'm guessing with respect. It could be the prosecutor, but he says, only answer me okay for the time being. It may be to the juror, but it kind of ends there. Or it may be in response to the fact that it is the prosecutor, to Justice Bell's point, that says, stand down. It's not much of an in-depth inquiry into the extent of, in relation to his lordship's own directions, what is the degree or the manner in which you know these people. You just know them, like we all know so many people. So I would say that there's not enough there that puts it into that second category. It's submitted the foregoing is not a proper consideration in accordance with the judge's initial direction on potential bias. And in any event, it was certainly not for the Crown to stand a juror down in the circumstances at this point. And in effective...
The gravamen of this is that the judge has said it's enough. And he's referring there to the fact that he knows the defendant's father, auntie, and the defendant. Not surprising that the judge might feel that this is an inappropriate person to serve on a jury.
My lord, it's not. I would respectfully say this one isn't the strongest one by any means, but I will also say there's 2 points to it, though, that should cause your lordship's concern, and that comes back to the appearance point. And it's this. One, it is, other than saying I know them, it is not any further questioning by the court as to, well, how well do you know them? His lordship makes out that going to school with somebody isn't enough. He says that quite clearly. That's not enough, man, that's not enough. So in this instance, there's no further inquiry to how you know these people. You're not making with respect, any type of questioning or examination of what degree, which is the law. And his lordship has set that out. To what degree do you know these people? Do you see them? Did you go to school with them? These types of questions. He does say it's enough, my lord. But your lordship's point is then the prosecutor that perks up and says, stand down. So the appearance of that with respect to the reasonable observer, but most importantly to the defendant, is there it goes. The prosecutor got another stand down or another standby, or another prosecutor got his way because he was the one that told the person, you're out, or you're going to the side, however you want to put it. It's that appearance. It's the prosecutor running the show on who steps aside. I'm sorry, I'm using another term, but whether you're standing them down or standing by. But I say effectively the answer is stand by, because again, my lord, to your point, there's no position that word cause is never used. The judge doesn't say, he does say that's enough. I agree with your lordship on that. But again, it's the intervention of the prosecutor that creates this concerning appearance, that this is not the way that it should operate. My lord, at paragraph Roman numeral 5, at page 17, paragraph 6, the Crown stands down juror number 13, Mr. Glassford, after he indicates he knows the names of 4 of the witnesses. The court in this instance makes no comment, my lord, no comment at all, or further inquiry, and the prosecutor, quote unquote, stands them down. So the court does not get involved in that one. That is just a simple.
Sorry.
Time on.
Can I be right that can I understand then your point is that where there is no sufficient investigation by the court as to whether there should be a challenge for cause, and the prosecutor at least appears to be taking the positive step of saying stand down or stand by or whatever, that is to be characterized as an actual exercise by the Crown of its rights to stand by.
Yes, Mom. I would say
that's the submission you're making.
It is, Mom. And I would say this, with respect, when your ladyship used the word appearance, the appearance of that to any observer can't be any other way in my respectful submission. We can't by some colorful artifice say, well, they're just stepping in to do the judge a favor. They should be mute at that point. And the
reality is the judge didn't make any comment at all there. So yes, that's rather stronger than the previous one.
It is stronger, my lord. Exactly. That's the point that I was making by including the other one. It's significant. So that, my lord, with respect, in my respectful view, must take me to 4.
Right.
Can I just be clear? If the transcript doesn't record the defendant's counsel doing anything at this stage, what does that mean?
It means they don't do anything, Mom. I mean,
yeah,
we have to go with
that's not significant. I mean,
no. I mean, I think Ms. Greening made the point with regard to these defense counsel, and probably any defense counsel on this call, they'd be heard if they had something to be heard about, and it would be a matter of the record. It's just not a matter of the record for whatever reason. And, we've discussed this as an interesting aside. All of us, I would say, all of us missed this for years. We really did. And just got in the habit, in a very bad habit, of allowing this to continue until Trot. And it just happened in Trot that the numbers fell the way that they did, that, I mounted the challenge there after 9. But it's the same thing. If it's not there, it's not there. Thank you, Mom.
Thank you.
At paragraph 6, so at page 19, paragraph 3, juror number 49, Clifton Webb is stood down after he indicates he knows the family of Nathan Darrell, the victim in the case. Again, in this instance, the court certainly makes no inquiry about the extent of the relationship or whether Mr. Webb is capable of acting without any bias, and it is the prosecution again that stands the juror down. Pause, my lordships and my lady. It's Bermuda. Darrell is a phenomenally common name. To say I know the family of Darrell doesn't take you anywhere with respect. Is it immediate family? Is it a distant cousin? And the reason, with respect, in the interest of justice, that I say there has to be some inquiry has to be made is because jurors don't always want to serve when perhaps they should. And that's the whole reason for it. So in this instance, again, all he says is, I know the family of Darrell. Not I know the defendant, not I know the defendant.
The important point, Mr. Pettingill, is that the judge doesn't say anything at all.
Exactly.
And, well, apart from at the top of page.
he says, with respect, it's not a submission, it's not a finding. He says nothing. And so that is another one where it's just the prosecutor runs the show. So now I'm at 5, my lord.
Yeah.
In my respectful submission. At paragraph Roman numeral 7, lords, at page 19, the crowd stands by, paragraph 14 stands by juror number 35, Angela Seaman, after she indicates that she knows Vance Hassel and Linda Wilson. The only inquiry by the court is for the juror.
What page are we on?
I'm so sorry, my lord. We're at page 19 of the record, paragraph 14.
Yep.
And that's in the same category as the previous ones, insofar as the judge didn't make any comment at all, and the prosecutor said, "Stand down."
Yes, my lord. The only comment the learned judge makes is repeat, in other words, the names. So that obviously is not a finding or a investigation. She says 2 names, and the prosecutor says, "Stand down."
Yeah.
Number 6, as far as the standbys go, my lord. So, my lord, my lady, at paragraph 10, what clearly happens in this case of the appellant Brangman is that the prosecution effectively, on hearing limited facts, executes an additional standby of a juror breaching what I say is the equality of arms principle of the appellant's constitutional rights as considered in the case of Jamaica Trot. And it's the appearance of that imposing themselves into removing or standing by a juror that must be the paramount consideration. My lords, the lord, my lady, indicates at 519. I'm sorry, my lord?
So that gets you to 6.
It does, my lord, yes. At least. And I say the other one, my lord, if your lordships were, I would respectfully say the one where there is some inquiry, if one looks at the directions, it's not enough.
It's academic, though, isn't it?
It is, my lord. I would say it was academic. It gets me to 6, if your lordships are with me on that. But I just, my lord, just to close this out then, what I say on the application of the law as it then was to your lordship's points, the Crown, the accused person may effectively challenge for cause any person drawn to serve as a juror in connection with a trial on the grounds that the person is not qualified by law to serve as a juror. That doesn't arise. And that's what you'd expect to see ahead of time with regard to these things. And B, the juror is not or may not be indifferent as between the Crown and the accused person. My emphasis, my lords and my lady, any challenge to a juror for cause shall be tried by the court before whom its accused person is to be tried. At no point during the jury selection is any juror formally challenged for cause, and at no time is the issue of cause tried, in my respectful submission, by the learned judge. Consequently, all of the challenges by the prosecutors are standbys. My lords, my lady, there's at least 6, and we're over that threshold.
Okay.
Unless I can assist further.
No, thank you very much. Mr. Mahoney, what do you want to say about Brangman?
Thank you, sir. In respect of Brangman, there were a total of 7. Well, I agree with counsel that there were 3 challenges without cause. In respect of the other 3 that counsel indicated, as
there are three pure standbys who don't come back, and so that they're the right sort, but you say not enough. But there are 3 that are indisputably Crown standbys.
That is so, sir.
Yes.
The others, sir, were, as we note from the transcript, that indicated certain connections, which, as I indicated earlier, once an issue is raised, the general practice was that they are stood down, and if you don't have a panel by the time you come back to the standbys, then we proceed to go through the standbys in the order in which they were stood down and for cause.
And did that happen in this case?
Well, we didn't reach the stage of going back to the standbys because we were able to empanel a jury.
So it's like Smith-Williams.
Excuse me, sir?
So it's on the same footing as Smith-Williams.
Yes, sir. But as indicated, there were sufficient concerns raised that if we had reached back to those jurors for cause, they would have been excused for cause.
But that exercise never happened.
It never happened, sir, because of the circumstances of the case, sir.
Yeah. Is that it?
Yes, sir. Just to indicate where counsel was making a point that the judge didn't say anything in regards to those three that had indicated certain connections with either the victim or other persons associated with the case. The judge need not have made any comment at that stage either.
But that makes them properly standbys, not challenges for cause.
Well, sir, having indicated the concerns that were raised, had we come back to the stand downs, those persons, based on what they indicated, would have been sufficient for cause.
Well, but
the challenge for cause was not being held.
For cause, Mr. Mahoney, the judge has got to hear the issue and make a determination, and that didn't happen.
Yes, sir, but that's what I'm indicating to you, that the practice is when you're paneling the jury in the interest of time, once a concern is raised, the juror is stood down.
Well, no, he can't be stood down. The wording of the act is that the Crown can stand by, and then subsection 5, any challenge to a juror for cause shall be tried by the court before whom the accused person is to be tried. So there's standby and challenge for cause. And we didn't get as far as the judge making a determination of the challenges for cause in this case of Brangman.
That's what I'm trying to explain to you, sir, that the practice is, rather than interrupting the empanelment of the jury to go into a trial for cause, excuse me, the practice is that once a concern is raised, that is deferred, so to speak, by standing down. The prosecutor normally stand by that person, and then if you exhausted the list, you come back to the standbys.
Yes, no, I understand all that. The only point I'm making is that while the words stand down were used, it was clearly the prosecutor's standby in those additional 3 cases in Brangman.
Yes, sir, that's all I'm saying, sir.
Yes.
So the judge...
What was happening really is that in accordance with local practice, as I think how you're putting it, the judge was in fact contracting out the decision on whether or not to allow a challenge for cause to the prosecutor. The point is raised, it's not investigated, and you stand up without any further investigation and say, stand down.
I would not agree with the observation that the judge was contracting out his obligation, sir. No. The practice was that the investigation into cause was usually delayed further down into the empaneling process.
Yeah. So is that it on numbers for Brangman?
That is so, sir.
Yes. In relation to the extremely interesting and sometimes difficult legal questions that are raised by your skeleton arguments, we've come to the conclusion that if anybody is an eligible applicant, those arguments are best left to a substantive hearing and not to be disposed of at this hearing. So we're concerned really with whether people can show the necessary degree of prejudice as a result of what went on in their particular case. So subject to anything my colleagues may say, I don't think we need to hear anybody on the difficult legal questions. They can remain difficult legal questions even if leave is granted. And if it's not granted, well, they can disappear into the ether. So I think we've probably got enough upon which to come to a conclusion about the grant of leave, subject to anything my colleagues may wish to say about wanting to hear counsel on any other issues. Justice Bell, anything else you want to hear?
I think that is clearly the position in relation to Smith, Williams and Brangman, where the number threshold was clearly passed. In relation to Roberts, it seems to me that the threshold wasn't clearly passed, so we have to make a determination on Miss Greening's argument as to whether
Yes.
it's irrelevant that they didn't get to the number because of the impression.
He says it makes no difference.
Yes.
Yes.
It's terribly ironic that the reason that they had to come back and look at the standbys or look at the remaining panel again is because the Crown stood by so many jurors to start with.
Yeah. Justice Gloucester, is there anything else you'd like to hear counsel on? Have we lost Justice Gloucester?
No, I'm still here.
Is there anything else you'd like to hear counsel on?
No, thank you.
Right.
My internet connection has just gone funny, but I don't want any further argument. Thank you. I don't need any further argument.
Right. Well, thank you very much.
If I may say so, quite timely. Mine is equally being disruptive now, and I'm struggling to hear what you're saying, but I think I've got the gist of it.
Well, we'll consider
if you don't need to hear from me further beyond that set out,
we'll consider the applications before us, extension of time and leave to appeal, and we'll try and let you know what we make of them by the end of this week. So thank you very much indeed, all of you.
Thank you, my lords, my lady.
Thank you.